Hey everyone, welcome to Wealth Redefined. I'm your host, Michael Reynolds, certified financial planner and owner of Elevation Financial. Thanks for joining me today for this episode. Today we're talking how to avoid probate. I've talked about estate planning on the show before. I think it's a super important topic that's often overlooked and full of nuance, but it's really an important part of planning your financial legacy and ensuring that your loved ones are taken care of in the event that you pass away. So estate planning can be complex. Doesn't have to be, but it can be. But a well-crafted estate plan gives you peace of mind, and also, again, shows love and caring for those that are left behind, those loved ones, if you pass away. So there are a number of estate documents that I feel everyone should have. I've talked about this on previous episodes. These things can include things like a will, trust, power of attorney, healthcare directives, other relevant documents depending on individual situations. And one consideration when it comes to estate planning is probate. So we're going to talk about probate today and specifically how to avoid probate. So let's talk about the why first, the what and the why before we get to that. So what is probate? Probate is the legal process through which a deceased person's estate is administered, ensuring the proper distribution of assets and the settlement of any outstanding debts or taxes. So when you pass away, your assets might include real estate, bank accounts, investments, personal property, things like that. They become part of your estate. The probate process is overseen by a court and typically involves the following steps. So first, validation of the will if one exists. The court reviews the will to ensure it's valid and reflects the testators, which is the person who wrote the will, their true intentions. So if there's a will, the court has to validate it, make sure it's legit. Then there's an appointment of an executor or a personal representative. The court assigns an individual. Often this person can be named in the will or appointed by the court to manage the estate and carry out the terms of the will. Then you take inventory and appraise the assets of the estate. The executor has to identify, gather, and appraise all the deceased person's assets. Then payment of outstanding debts occurs, taxes, expenses, etc. The executor uses the estate's assets to pay off any outstanding liabilities, including taxes and funeral expenses, and then distribution of remaining assets. So once the debts and expenses are paid, the executor distributes the remaining assets to beneficiaries specified in the will or according to the state's intestacy laws if there is no will. So intestacy means if there is no will, the court just decides. Someone who has passed on without a will is said to be intestate. So there are downsides to the probate process, which is why many people look for ways to avoid probate. So why would we want to avoid probate? So several reasons. One, it can be costly. Probate can be expensive. There's fees associated with court filings, attorneys, executor compensation. Those costs can consume, a significant portion of the estate's value, which reduces the amount available to beneficiaries. Time can also be a factor. Probate can be a lengthy process, sometimes taking months, even years in some cases. And during this period, assets might be frozen, leaving beneficiaries without access to funds or property that they're due to inherit. So avoiding probate can expedite the distribution of assets to those intended recipients. Privacy can also be a concern. Probate is a public process, which means that the details of the deceased person's estate, which include the value of assets, outstanding debts, the identity of beneficiaries, all become part of public record. So avoiding probate can help maintain privacy by keeping sensitive financial information and these family dynamics confidential. Also, family conflict. The probate process might increase the likelihood of disputes among different family members because it provides an opportunity for contesting the will or challenging the executor's actions. So by avoiding probate, you can reduce the potential for conflict and ensure a smoother transition of assets to beneficiaries. Also, asset protection. Bypassing probate can, in some cases, provide added protection for your assets. It can shield them from creditors or legal claims against the estate. So to avoid or minimize the impact of probate, there are various ways to engage in estate planning strategies, and we're going to talk about those things right now. So how do we avoid probate? Several strategies. One of those strategies is to make use of a living trust. A revocable living trust is an estate planning tool that helps to avoid probate because it transfers ownership and management of your assets to a trust during your lifetime. So here's how it works. So first, you create the trust. You create a revocable living trust by drafting a legal document called a trust agreement. And this document specifies the terms of the trust, names a trustee, which is usually yourself during your lifetime, and designates successor trustees and beneficiaries. Then you fund the trust. You transfer ownership of your assets, such as real estate, bank accounts, investments, other personal property, to the trust. This is accomplished by changing the title or ownership of documents to the name of the trust. And then once assets are in the trust, they're considered trust property and no longer part of your personal estate. Then, as far as control and management, as the trustee, you retain full control over the trust assets during your lifetime. You can buy, sell, modify assets, as well as revoke or amend the terms of the trust anytime you want. There's a successor trustee as well. So upon your death or incapacity, the designated successor trustee takes over the management of the trust. This person is responsible for carrying out the terms of the trust agreement, which can include distributing assets to beneficiaries or managing the trust on your behalf. So this avoids probate since the assets in the revocable living trust are legally owned by the trust and not by you as the individual. They don't form part of your personal estate and therefore they're not subject to probate. The successor trustee can distribute the assets directly to the named beneficiaries according to the terms of the trust, again, which bypasses probate altogether. So the nice thing about a living trust is it avoids the time-consuming, expensive, and public nature of probate. Because by passing assets through a trust is private. So it allows more efficient, more privacy. And those are advantages of a trust for avoiding probate. So next, beneficiary designations on retirement accounts. This is huge. This is a simple thing that many people overlook. So when you have retirement accounts, such as 401ks, IRAs, or other qualified retirement plans, you can name a beneficiary on those retirement accounts. You can name more than one. You can name multiple beneficiaries or a beneficiary and contingent beneficiaries as backup. You can assign those directly on the accounts. So you designate beneficiaries on the accounts. They can be changed anytime during your lifetime. You retain ownership and control of these accounts. Then when you pass, the transfer to those beneficiaries is automatic. It's an automatic transfer upon death. The retirement account assets transfer directly to the designated beneficiary without the need for probate. All the beneficiary needs to do is contact the financial institution managing the account, provide a copy of your death certificate, and follow the institution's procedures for then claiming those assets. So it's a streamlined process, much more efficient, pretty much immediate and direct. So you want to make sure that you keep those beneficiary designations on retirement accounts up to date. These are things like 401ks, IRAs, other qualified accounts such as cash balance plans. Also, many investment accounts allow you to do a transfer on death, which is a similar type of vehicle. So make sure those beneficiary designations are up to date. Next, joint ownership with rights of survivorship. This is a type of property ownership in which two or more individuals jointly own an asset, such as real estate or bank accounts or personal property or investment accounts. It's an effective way to avoid probate for jointly owned assets because there's an automatic transfer of ownership when one party passes away. So when one of the joint owners passes away, their share of the property automatically transfers to the surviving owner without the need for probate. So that is one advantage of joint ownership with rights of survivorship accounts. It's simple, it's straightforward. Again, ownership passes directly to the surviving joint owners. Next, payable on death accounts or POD. These are also known as Totten Trust, not really used as much anymore, but the POD account is basically just a designation of a beneficiary for a bank account. Things like checking accounts, savings accounts, certificates of deposit, savings bonds. These often allow you to designate a beneficiary, which will inherit the account funds upon your death, similar to a beneficiary on a retirement account. So you set your beneficiary. There's no ownership on no impact on your ownership, just like a beneficiary on a retirement account. When you pass, those assets pass directly to the beneficiaries named in that POD designation. That's called payable on death designation, typically for bank accounts. Also bypass probate. Next, transfer on death deeds and registrations. Transfer on death, or TOD. It's also known as a beneficiary deed. It's an estate planning tool that allows you to pass real property, such as real estate, on to your designated beneficiary upon your death. So what you do is you execute a transfer on death deed. It's a legal document that you put together. You file it with your county, and then once you record that, again, with your county or land records office, you retain ownership of the property. But when you pass, that property passes directly to the beneficiary named in that transfer on death deed. Again, bypassing probate. It's an automatic transfer. You do file some paperwork, a death certificate, et cetera. But then once that's done, the transfer of ownership is immediate, private, bypasses probate, and again, doesn't go through the lengthy and costly process of probate. You can also use TOD deeds for, parcels of land, pretty much any, real estate type, single family, condos, et cetera. Not all states support or allow transfer on death deeds, though. So make sure you check with your state. Some states do, some states do not. It's state by state specific. So for non-real estate assets, like say a vehicle, for example, there's a similar concept called a transfer on death registration or a beneficiary designation for a vehicle. So many U.S. states allow this, where you can go to your DMV, file the paperwork for a transfer on death registration, and your vehicle can be transferred in a similar fashion. Also, businesses, you can have a TOD registration set up for a business, or it can be named in the operating agreement, where if you pass, your business or the share you hold in your business or shares will be transferred directly to a beneficiary using this paperwork. So if you own a business, let's say you're the sole owner, and you want to make sure that your business passes directly to a beneficiary who can take over the business, maybe run it properly, keep everyone employed, keep the continuity there. It's a very good idea to consider a transfer on death registration and or amend your operating agreement to make sure that you specify a succeeding owner when you pass away for the business. Also, your life insurance policies and annuities, these have beneficiaries. You want to make sure these are up to date. When a life insurance policy pays out upon your passing, that passes directly to a beneficiary. So make sure those beneficiaries are up to date. They work exactly like beneficiaries on a retirement account. The proceeds pass directly to the beneficiaries named on life insurance. Finally, gifts. Gifting can be a good strategy to avoid probate, because when you gift during your lifetime before you pass away, it's private, it's direct. Transfer ownership is immediate. It reduces your estate size and reduces the things in your estate that would go through probate. You can control who and when and the timing of this gift, and also immediate benefit to the recipient. It's also worth considering, hey, should I wait until I pass to distribute these assets to my heirs, or should I make a gift now and allow them to enjoy the benefit of that gift now? And maybe I get to enjoy seeing them enjoy the benefit of that gift. So don't forget about just gifting as a strategy to avoid probate, and has some other advantages. So while you're considering this, though, be aware there are gift tax implications. So for the vast majority of people, these probably don't apply, because the threshold of gift tax is pretty high. It's in the millions. But just be aware of that. So if you have a higher net worth, that could be a factor. But for the vast majority of people whose estates are not in the multi-millions or tens of millions, then it's not going to be a factor. But be aware that if you gift over a certain amount, you do have to do things like file gift tax returns, et cetera, and track that. So just be aware that those are factors. So those are some ways to avoid probate. So just kind of a checklist summary to review. So if you want to consider avoiding probate, here's the action steps to think about. 1, consider creating a revocable living trust. That can be a good way as kind of a catch-all in a broad sense to avoid probate with your assets. Also, consider joint ownership with rights of survivorship account titling if you have joint ownership with someone else. Establish payable on death accounts. Designate beneficiaries on your bank accounts using POD designations. Make use of transfer on death deeds or registrations for things like real estate, maybe even vehicles and businesses. Make sure those are set up to transfer ownership directly upon your death, bypassing probate. Make sure your life insurance policies and annuities have current registrations for beneficiaries. Make sure those are up to date so you can control and define who those beneficiaries are that receive those assets bypassing probate. Consider gifting assets during your lifetime. If you want to avoid probate and observe your heirs, enjoying the benefit of those assets before your death, it's a good thing to consider. Consider gifting. And make sure your beneficiary designations are up to date on your retirement accounts as well. Make sure all those beneficiaries are current and defined the way you want them to be defined. So that's kind of a summarized checklist. So as always, before implementing any of this stuff, be sure you consult with an estate planning attorney. Make sure they're appropriate for your specific situation and address any potential issues or complications that might arise from executing on any of these things. So with proper planning and execution of these steps, you can avoid probate and provide a smoother transfer of assets to your loved ones. So I hope that has been helpful in understanding the ways you can avoid probate, the why behind possibly avoiding probate, what the whole process looks like. And that way you can make an informed decision on if and how you want to avoid probate upon your death. All right. As always, happy to chat anytime. As always, I'm easy to find. I'm at elevationfinancial.com. You can reach out through my website, send me a message, or better yet, feel free to book a complimentary money session using that button on my website. Happy to chat about this or any other questions you might have. And as always, thanks for joining me today. Have a great day. We'll see you next time.